everyone, welcome to the Immigration Talk Show brought to you by Sakshi TV. My name is Ranjit. We are here today with the attorney Prashanthi Reddy to discuss the latest updates on immigration, followed by H1B updates and Q&A. You can call the numbers displayed on the screen and ask any question related to immigration, and our attorney will be glad to answer. We'll start taking calls in few minutes. Before starting the show, I would like to repeat the disclaimer. Please note this show does not provide any legal advice. It is general in nature and it is only for informational purposes. Sakshi TV news and agents are not responsible in any way for your actions. Please use the information at your own risk. If there is a case-specific scenario, please reach out to attorney to discuss more. If you would like to reach attorney Prashanthi for a private consultation, please reach at 212-354-1010 or prashanthi@reddyesq.com. Hi Prashanthi Garu, welcome to the show.
Hello, how are you?
I'm good. How are you doing, Andy?
Good, thanks.
So yeah, before we start the show, can you give if you have any latest updates from the last week, and then we can take it from there.
So we have quite a few, so I just wanted to make sure that I had all the information in front of me. So basically, this to start off with, USCIS is allowing employers to file a motion to reopen. This is very key. So they're allowing employers to file a motion to reopen for all those cases that were denied, in the past years. Obviously, when I say past years, it can go only until the validity of the H1. So since the H1 is given for 3 years, you can't go beyond 3 years. So because if you're going to look at cases older than that, they won't be valid. So even if they approve them, the validity period would have expired. So anything that is within 3 years, or I would say at least 2 years and 6 months, because you need at least 6 months you want to have at least 6 months of validity. So any of those cases that you have filed, these are for those employers and as well as for the beneficiaries. If you have filed cases, or if you are an employer and you have filed cases for your employees, and if they were denied based on the right to control or the employer-employee relationship, or due to not submitting contracts and itineraries, or because you submitted a PO and you didn't submit, they asked for something else like the end client letter and you were not able to submit it and they denied it based on that. Or if your H1 got denied due to specialty occupation because you filed it under a systems analyst or computer analyst related position, and they said that, as per the Labor Department handbook, it's not a specialty occupation because it requires a bachelor's degree in more than one field. So I know what I'm saying, there's a lot of information I'm giving, so you need to reach out to an attorney to see if you qualify for your case to get reopened or not. But even if there's a 50% chance, I think you should do it, because refiling that case opens up again a new can of worms. So you don't want to refile, you'd rather just file a motion to reopen. And also, if it's a cap case, you can't even refile. You have to file under the cap, and tomorrow is the last date, right, to file cap cases. So I think a motion to reopen is extremely useful in this situation. All this is a result of some policy memos being rescinded by USCIS. So they rescinded the employer-employee relationship policy memo. They rescinded the contracts and itinerary policy memo. They also rescinded the computer programmer policy memo. So they're trying to give relief to those cases that were denied in the past, which is very rare for them to do that, and they're allowing you to file a motion to reopen. Usually a motion to reopen can be filed only within 30 days, but they're making an exception to that, and they're saying that they're allowing a motion to reopen to be filed, even though, several years may have passed.
So is there any specific dates USCIS mentioned about this, that, if it falls on a certain date, they can reopen, or is it like you can go back?
So there's no specific dates, Nizam. There's no specific dates, Ranjit. Basically, the dates are the validity of the H1 is what is important. So if I have a H1 was valid, it's usually valid for 3 years, right? So if that 3 years period is over, obviously you cannot file, because even if they approve it, then it's of no use to us. because they will approve an already invalid H1. So just make sure that the validity is not over on these cases. So there's no specific dates other than to look at other than the validity of the H1.
Okay, we have the caller again. Hi, Gurudatta. Welcome to the show. Please go ahead and ask your
Hi.
question.
Hey, thank you so much. Yeah. So I have this question related to a H1B regarding, this is regarding my fiance actually. So she has been in India, and what's happening is, so her company filed an H1B in 2020, that is last year. So, but it never went to a place where she could get it stamped and all, right? Because of the COVID situations and all, they did not send her for stamping. But however, she got the approved petition with I-797. So when they were about to send her beginning of this year, or probably after March, that is till March we had that President Proclamation rule. So they were planning to send her in April. But then at the end moment, they got to know that the vendor for which the client for which they have initiated her H1 or got it approved are no longer, accepting the vendor. Like that vendor has lost the client, kind of a thing. So now there is no other option for her to file or change the job within the company or the same employer where she can get any other project. So that is her issue. And what my thing was, if we are getting married next month, and I'm planning to call her on H4. Bring her here on H4. I'm in actually Charlotte in US from past 8 years. So I'm calling, trying to get her on H4. But meanwhile, what I wanted to know is that if we somehow manage to get a copy of her I-797, that is approved petition from our employer, will there be a possibility to get that transferred to many other employer when she is here, while she is here? Or can that in any way be processed as a cap exempt case, or it has to again go through a lottery process as a new fresh H1? That is something that I want to know.
Right. So to start off with, I'm thinking about looking into whether the same H1 can continue to be processed, because we are talking about the vendor not being available, but the client is still there, and her employer still, prospective employer still has the job, right? So why can't you use the same?
Change her company right now is what her the decision that they are making on their side is that they have to quit the employer that she is with right now, and they have to move to a different employer altogether.
Why can't they get a contract signed, bypassing the vendor, get a contract signed directly with the end client? Because we already have an LCA for the work site. The H1 is already approved for that work site. It's the vendor is of no consequence, right? Unless the employer himself doesn't have that project anymore. As long as the client is willing, it's the entire process can still continue, right? That's not an immigration thing, but it just logically, that is something. It is also an immigration thing, because your question might be, what if the vendor changes? Does something change in the petition? No, the vendor is of no consequence. It's only the employer and the client.
Vendor as in, sorry. When I say vendor, I meant the employer. So her employer is changing.
Okay, so then, yes. Yeah. Often using the right terminology is so important, especially in our world, right?
Sorry.
So, so if the employer, then there's nothing you can do. So back to your next question about whether she's cap exempt or not. I think that is basically the crux of your question. She will not be cap exempt if she has never worked on a H1. So that's the strictest interpretation of who is cap exempt and who is not. So what will happen most probably is you will file when she comes here on a H4. If she qualifies for a H4 EAD, then you will file that obviously, or you will file under next cap. And if she doesn't get it under next cap, then my suggestion is to, or even before, if you want to take a chance, because there's no time now to file under this cap, right? You can try to file it and see if it gets approved as a cap exempt. And if it doesn't, then go for a cap subject case next year. That's my suggestion to you. Because it is not, if they follow the strictest interpretation of who is cap exempt and who is not, a person who has never worked on a H1 in the United States is not cap exempt. Simply because they have an H1 approval, that doesn't make them cap exempt. That's how they have been interpreting the law. But it really depends on, there's a new administration now and depends on the officer. So I've seen some cases go both ways. And since we have no choice now, other than to wait until next year, you might as well bring her on a H4 and then try to file for a change of status as a cap exempt. Does that make sense?
Yeah, that makes sense to me. I mean, I just wanted to clarify with you. So the other thing is that, so if we have the I-797 copy with us, would that in any way help in any way, or is it of no use at all?
It doesn't matter. It really doesn't matter.
It doesn't matter.
No.
Okay.
Because she's on a H4. She'll be on a H4 when she's filing for the H1. So it only matters if you're filing as cap exempt, right? So yes, sorry. If you're filing as cap exempt, then you have to show that previously there was a H1 approval. So if you're filing under the liberal interpretation and hoping that the case will get approved as cap exempt, then yes, you need a H1 approval to show that she was previously on at least had a H1B approval, right? But if you're filing as cap subject next year, then you don't need that H1B approval. So you need it only as proof that, of being cap exempt.
Okay, I hope that answers your question. We have another caller, Koti from Atlanta. Hi, Koti. Welcome to the show. Please go ahead and ask your question.
Thanks for the opportunity for both of you. And presently, I'm on H4, and my previous H1 was rejected. That time, 2019, I went to India, and on H4, I came back US. Now, presently, I'm on H4, and after coming back from India to USA, within 1 month, my H1 was approved. My extension and H1 was approved with one of the employers. So now I am going to India in next month. I am eligible for the Dropbox or not? The reason I am an H4.
If it's not only H1 extensions are eligible for Dropbox. If it's not an extension, then you're not eligible. So when you came back to the country, what happened? Did you previously file? So your fact scenario is not clear. When you came back on a H4, did you again file for change of status from H4 to H1, or some previously filed case got approved?
Previously filed one is approved. Yeah.
So when the previous filed one got approved, did it get approved with I-94?
Yes.
Or consular processing?
I-94.
Right. So the problem is you can try for Dropbox, but it's a little tricky because as per the last action rule, whatever you did last, that becomes your status, right? So even though you filed a H1 extension and it got approved, when you came into the country, you came on a H4. I'm just thinking while we're talking. But since you initially filed the H1 as an extension and it got approved, I think you can try for the Dropbox.
Yeah, I think as
you might meet the requirement.
When you're scheduling appointment, it only asks for 4 questions. One is if you had similar visa that is expired in last 48 months. Now it is 48 months. So if you had an H1B stamp in the passport that expired in last 4 years, you should be eligible.
So 24, 48, 2 years. They extended it recently to 2 years from 1 year. So I don't see. I'm just looking at it.
48 months now. It's 48 months. Yeah, it's 4 years.
4 years, correct. Sorry. So if I'm just looking at it in depth because that's what attorneys do. They look at all the perspectives, right? They don't give
but while
you a straight
scheduling,
answer.
It only asks 4 questions.
Right. But when you actually put in the Dropbox, they might investigate further as to whether you're eligible or not, and they might call you for an interview, right? It doesn't mean that those 4 questions are the, everything. They might do further investigation and see what your situation was. But most probably you should be eligible for Dropbox. I would definitely try the Dropbox.
Okay, hope that answered your question. We have another caller, Sridhar from Virginia. Hi, Sridhar. Welcome to the show. Please go ahead and ask your question.
Hey, thank you, Prashanthi Garu, and thank you. My question is, recently we have submitted our EB3, I-485 downgrade case. We have concretely filed our I-485 petition along with the downgrade of I-140. Unfortunately, what happened is the case got rejected, saying that incorrect payment. But
Incorrect what?
then we realized that incorrect fees.
Fees. Okay.
Okay. And all full 140 downgrade 140 485 everything got rejected because of incorrect fees. We are 100% sure that we sent the checks and proper fees, but when the packet returned after rejection, the checks were missing. The whole four checks were missing. The one check is issued by attorney, the other three checks is issued by myself. All four checks was missing in the written packet. But the biggest, and what my attorney did is they refiled immediately within a week with the same case. But what we are observing right now is if the dates are not
No,
current,
but even if they
they are
refiled,
rejected.
if the dates are not current, they won't accept, right? Did they refile when the dates were current or no?
Yeah, now the dates are not current. But here the mistake is
So
we haven't
when
done any mistake.
no, can you answer my question? Did they refile
Sure.
the case when the dates were current or after the dates retrogressed?
No, after the dates were
Okay,
not current when we refiled the case.
okay,
But the
okay,
problem is
fine.
here, we have every documentation to prove that we sent every check. But the biggest
So
problem is
what documentation do you have?
we have a complete scan copy of whatever we sent. The whole
Right.
776 pages of document, everything. My attorney said that we have documented under documentation rule, business documentation rule. That's what she maintained. But the biggest problem is now within a group we found that there is another same case of things they didn't accept it. But how do we prove?
They are
We sent
actually,
everything.
just for your knowledge, there are quite a few cases like that where people have sent checks and the checks have disappeared. There's one interesting case in our office, basically, where we sent the checks, separate checks, right, for I-140, each dependent 485, because we intentionally send separate checks so that they don't say that it's missing. Because the more number of checks you send, if you send one check, they're likely to lose it. They can't lose 5 checks, but obviously from your case they can, right? From what we see in the other cases. But what happened in our case is that they sent back only the checks, dependent case, saying that there are no checks for this case. And we looked in our scan copy, the checks, everything is scanned. Then the interesting thing is, after a few weeks, they sent back the dependent check saying that this is an extra check, we don't need it. First, they sent back the dependent case. Then they sent back the dependent check saying this is an extra case that the primary applicant, extra check that the primary applicant has and he doesn't need it. Can you believe that? So they actually had the check and they're saying they didn't have it. Then they sent back the check saying that it's not needed because they don't have any dependent file. So it's interesting what is happening. And in that situation, we sent the case back as well, with an affidavit saying that, everything was submitted properly. We have documentation, scan documentation. It's still pending, so we don't know whether they'll accept it or not. But they should, because in our case, we have proof that they are the ones who sent us the check because there is a note from them and the check has been stamped. So weird things are happening. But we can only watch and wait. But AILA is trying to help, and so far nothing has happened with reference to these returned cases. But we're hoping that either dates for filing will become current again in October, which will allow us to refile these cases. We know the final action dates are moving quickly. Or they should come up with some policy whereby these returned rejected cases can be resent, because there are about 10% cases have been returned, and that's a lot.
Okay, I hope that answered your question. We have another caller, Sunil from North Carolina. Hi, Sunil. Welcome to the show. Please go ahead and ask your question.
Thank you. You've been providing great service. so far. So this question is about my dependents H4. So I have filed H1B extension last year, May 28, 2020 to be specific. And then my extension was approved within 2 weeks or 3 weeks or so. And after that, H4 dependents, I think we got the biometrics as well, and we were able to complete the biometrics. And then we had to wait for the H4 extension. So we had filed numerous service requests. We had reached out to ombudsman. Congressman was of no use in North Carolina, unfortunately. And finally, we were able to file a motion or a lawsuit against USCIS with the help of another attorney. And finally, my wife's H4 EAD has been approved since then, October, and she was able to work. Now, the problem is my kids, dependents, who are in the same status. Their H4 status is stuck since last 11 months or 10 months or so. And I tried to reach out to USCIS in multiple ways, like on phone calls, they never respond. These days, I'm not even able to respond to them on the phone call. And I've been raising service requests. And unfortunately, I don't see any updates from them. Now, the problem is that I have to travel to India in future, maybe down the line in 3 months. And then I'm not really sure how to handle the H4 EAD, H4 status of the kids there. Any suggestions in this point?
So if they're traveling, then your problem is automatically solved, because if they leave the country, they will get a new I-94 for which matches your H1. So you don't have to worry about that extension that you filed. All you need to do is take the receipt as proof that you filed the extension and they're not out of status.
So I'm going for a Dropbox in India. So will I be able to get that information? How do I get that information? Like, the latest information of my kid's extension is approved. Like, should I be able to check that after I cross the borders, international borders from India to US, or where do I check that? I'm really sorry, I'm asking this on.
So you're going to the consulate. You're going to the consulate for a visa, right? Do your children also have to get a visa? I'm guessing that their visa is also expiring.
Yes. Their I-94 is expired, and we are all going to India to get the Dropbox eligible. We are eligible for the Dropbox with the recent updates, and now I'm actually trying to choose the Dropbox, appointment in the USCIS. In the Hyderabad consulate, and I'm trying to see if my son's H4 is also extended, so that I don't need to worry that that they are something, and I should provide answers when I'm in India.
Right. So what I'm saying is that you don't have to. All you need to do is take the receipt that you filed on time. It is not your fault that it hasn't come. That's USCIS's basically, their inability to process cases on time. So just go to the lockbox, submit you can put up a copy of the receipt that you have, the H4 receipt, if they ask for it. And they should be able to get their visas. It does not, so as you know, for a H4, you don't need to show a 797, right, to get a H4 visa.
Right.
Based on your H1 I-797, they give automatically the same validity visa stamped for your dependents as well. So follow the the lockbox rules and put all your passports in the lockbox. If they need anything, they will reach out to you.
Thanks, Prashanthi.
You're welcome.
Prashanthi garu, we have a caller, Dheeraj from Virginia. Let's take the call. Hi, Dheeraj. Welcome to the show. Please go ahead and ask your question.
Okay. Hi. Thank you for giving this opportunity, ma'am. So actually, I applied for. I'm in H1B right now, and I applied for H4 for my wife last October, and it's still seeing. I'm seeing still the process is going on from like 6 months. I see the wait times are a bit longer than usual. I think it's because of COVID, but I'm just trying to join my wife to a college, and the DSO is saying to we can do the masters in part time, and only once your H4 is approved, she can do a full time masters. So if I do in this way, future if I try to apply for her OPT status, is that would be a problem, or I just need to wait until the H4 is fully processed and start the masters? Like you can give me any suggestion or advice on this.
Yeah, I guess you have to follow what the DSO is saying, because unless you have H4 on a H4 status, you can be a student. So you have to wait for the H4 to get approved, I guess, and follow up with them. And there is a delay with reference to even H4 processing, not just H4 EAD, which is a bigger issue. But a lawsuit was filed recently, I think yesterday or today, by ALA and some private attorneys with reference to H4 delays. So hopefully that should benefit everyone, and the processing times should become more reasonable, but let's wait and see. But with reference to your question, yes, you need to wait for the approval before you can become a student, so that, you have to follow what your DSO says.
Prashanthi garu, follow-up question. Also, I believe to be eligible for OPT, you have to be on F1 visa, right? You can't get an OPT on
Correct,
H4,
yes.
right?
On you cannot get an OPT.
Yeah. So you have to. So I believe
You can
in this
you can get
scenario.
a H4 EAD and work if you want, but yeah.
Yeah.
For an F1, OPT, CPT, all those benefits come only if you're on a student status.
So you can probably study on H4 for a couple of semesters, and at least by then you have to move on to F1 to avail the OPT.
F1, or if he's not they're maybe not
Yeah.
interested in working, but they just want to study, that's possible.
Yeah.
Or
When
maybe if they get a
it
H4
specifically
EAD.
talked about OPTs, I was like, is it possible on H4? No, no,
No,
right?
we can't. I don't know if he's still on the call, but yeah, it's not possible on a H4.
Got it. Hope that answers your question. If you need more information, please reach out to the attorney. Prashanthi garu, do we have any updates on the visa bulletin and Department of State? I believe there was a video call last week. If you can share some updates, that would be great.
Right. So I was just sharing, the updates. We had talked about this whole RFE thing that, motions to reopen can be filed with cases that are pending. Cases that are approved but denied due to, the three reasons: right to control, employer-employee relationship, which is basically the same thing, also itineraries, lack of itineraries and contracts, and also specialty occupation. So that accounts for like 65% or more of the denials. So there's a lot of cases that can be reopened. The other update that I wanted to talk about was the the extension. We've received an extension. This is news that we've received today. They since the beginning of the pandemic, they have been giving extra time. USCIS has been giving extra time to respond to RFEs, NOIDs, NOIR, notice of intent to revoke, notice of intent to deny, motions to reopen. Everything has a deadline, right? So whatever the date is on that notice, they're giving extra 60 days. Now that was going to expire end of March. Now they've extended it again by another 3 months. So that is good news. We still have that 60 days grace period, and they have been extending it by 3 months every time. So let's see if we get another extension. So all those of you who have RFEs or any kind of deadline with USCIS for a request for further evidence, you have a 60 days grace. The other update that I wanted to share was the public charge. That's a big, big issue, and I wanted to share that we no longer have to worry about the public charge rules. For those of you who don't know, in the beginning of the pandemic, in February actually, the Trump administration came up with new criteria for approval of non-immigrant and immigrant petitions. So as per the previous criteria, especially for immigrant petitions, green cards, family-based, employment-based, whatever it might be, you only had to show that you were never a public charge in the past, meaning you never took food stamps, you were never on welfare. Now with this new criteria, they were saying that you also have to show that you are not likely to be a public charge in the future. And of course that you have not taken any assistance in the past. So this is a very subjective evaluation, because how do you evaluate if somebody is going to become a public charge or not? It's hard. Yeah, obviously a person who has a job and presently maybe they will say that he's not a public charge. But what about person who doesn't have a job, it doesn't mean that they'll become a public charge. It's possible that their family members will take care of them, right? For example, Indian nationals file for their parents or file for their spouse. They may not necessarily work in the US. Does that automatically mean that they'll take public assistance? We don't, right? Usually, we look after our family members. So to presume that just because someone is not working, they will be a public charge is number one wrong. It's incorrect presumption. And number two, it's very difficult to show just because they're not working now that they won't work in the future. It's difficult to prove that fact or to make that judgment. And so a lot of cases, all dependent cases, all family-based cases, all dependent employment-based cases can be rejected on these grounds. So I'm very, very happy that now the Supreme Court basically has closed the case because the Biden administration has decided to withdraw the public charge rule. And so we don't have to worry about that anymore. It was a big headache for us in October, in the month of October, when we had to file all those cases because the visa numbers became current. 300, 400 pages of public charge documentation had to be filed. And because of that, it was very burdensome for attorneys to be able to file, all the cases that they had on time and accurately. And this is one of the reasons for all, those 10% cases being returned, due to some problem or the other, is because there was no time and then there was this additional burden of the public charge document. So happy to report that that's gone.
Sorry to interrupt you, Prashanthi garu. We have a
Sure.
caller. Let's take the call. Hi, Sai. Welcome to the show. Please go ahead and ask your question.
Hi, ma'am. I'm calling from Arizona. So I have a question regarding that. My H1B was approved, and I just want to go for stamping this year. And my client was not able to give me the client letter, but my vendor can give me the letter. But I see a lot of stamping experience that client letter is really mandatory to go for the first time stamping. Now I am changing my status from F1 to H1 now. So is client letter is really mandatory, or we can provide any email from our manager or something like that? I just want to know that.
So with reference to at least USCIS, things have changed a little bit, and they're no longer giving as much importance to a client letter as they used to. Even in the past, it was not mandatory, the client letter. It made sense to give it because it's more likely to get approved if you have a client letter. But they have kind of softened their position with reference to the client letter also. And the only reason they're asking for the client letter now is not to show that there's a job, because you can just submit a purchase order to show that a job is available. But they're asking to make sure that that you have duties which are specialty occupation duties. So for that reason, they are sometimes asking for the client letter. So it should be the same with the Department of State as well, because after all, they have to follow what the USCIS regulations are. So even if you're able to take an email instead of a client letter, detailing all the duties and the start date, end date, job title, right to control language is no longer needed. But if you're able to take even an email, that should work. But remember, whenever you go for a visa, it's always discretionary. So no one can actually say 100% that you'll get the visa. But from a reasonable perspective, it should work. Because as long as you submit what they're looking for, which is via an email, doesn't have to be via a letter.
Sai, I hope that answered your question. Yeah, Prashanthi garu, we were talking about the updates. We were just
Right.
talking about the public charge rule, which is gone.
Right. Also called the wealth test. So, and it was so criticized because they were basically encouraged giving green cards to wealthy people and not to poor people. So they're basically saying, passing on the message that America doesn't want the poor, they only want wealthy people. So that there was a big.
Sorry to interrupt you again. We have another caller, Abdul.
Sure.
Hi, Abdul. Welcome to the show. Please go ahead and ask your question.
Hello, this is Abdul. I got my H1 approved in 2019, and I have another year pending. I'm from Houston, Texas, and I'm planning to go for H-1B stamping in the next couple of months. Right. I have a question about the specialty occupation. So my designation or position is business intelligence developer, and the LCA is for application developer. So my question is regarding the specialty occupation. How does it affect the designation that I have versus what's mentioned on my LPA?
So what is important is not what your job title is, but what your job duties are. So as long as the job duties that you mentioned in your petitioner letter match with the job duties that you're actually working on, which is, and the proof of that is either a vendor letter or a client letter. As long as the duties match, it doesn't matter that internal job titles can be different. A client may give the exact same duties but have a different title, and your employer might call it something else. So, USCIS has always said over and over again that job title is not important, but the duties have to match.
Abdul, I hope that answered your question. Yeah, Prashanthi, we were talking about the public charge rule.
Yeah. And then so the next update I wanted to give was about there's this presidential proclamation. It's not a new update, but this is, I've noticed a lot of people don't know it. Trump, during the Trump administration in October 2020, basically before that, in the summer actually, he published a proclamation called 10052, which basically said that anyone who was out of the country as of the date of the proclamation cannot come back in until December 31st, which was again extended before he gave over power to the Biden administration. It was extended to March 31st. So non-immigrant visas are not being issued because of this proclamation. But there are several exemptions to this proclamation, and people are not paying attention to that. And if you're an employer or you're an employee, one of the important exemptions is that there was a court case in October 2020, and several, the National Association of Manufacturers and U.S. Chamber of Commerce and National Retail Federation, TechNet, Intrex, these were all the plaintiffs in that case. So the district court decided that the proclamation was unlawful, but unfortunately it applies only to members of those organizations. So if you are an IT company or any other company, and if you become a member, for example, of the US Chamber of Commerce, which is very easy to do, go to their website and ask for membership. If you're a member of the US Chamber of Commerce, for example, it's automatically an exception. Then they cannot, the Presidential Proclamation 10052 doesn't apply to you. So keep that in mind, all those employers filing for your cap cases this season. If that March 31st deadline extends, because remember, the Biden administration has rescinded the presidential proclamation with reference to family-based immigration visas, but they have not said anything yet about this exemption for work visas. So we are still waiting and watching to see what they'll say about it, whether they'll extend it after 31st or they won't, or they'll amend it in some way. But if it does get extended, please keep this in mind, that by becoming a member of the National Association, one of these U.S. Chamber of Commerce or Intrax or TechNet, you will be exempt from that visa restriction, and your employees will be able to go for a visa.
Sorry to interrupt you, Prashanthi. We have a caller, Sandeep. Hi, Sandeep. Sure. Welcome to the show. Please go ahead and ask your question.
Hi, ma'am. Thanks for giving me the opportunity to talk to you. I have a question. I'm an STEM OPT, and my visa, I applied for H1 this year, so there may be a chance if I get approved or not. But if I didn't have a chance, so my STEM is expiring on next Feb 2022. So I just, and my wife is here with me for F2, and she want to apply for F1. So for applying for F1, is there any chance that we have to go out of country for applying for F1, or is there any way I can apply her from here itself? That's my
So
question.
if she is presently on an F2, you can apply for a change of status to an F1 by filing an I-539 form. So it's possible to do that
Okay.
by staying in the country. You don't have to leave the country to do that.
Okay, so there won't be any issue regarding like change of, because I heard some of them saying like if you are nowadays they are not accepting, like you have to step out of the country for changing the status.
No, that's not completely true. It's only partially true, and it's not true for F2s. It's more closer to the mark for if you come on a visitor's visa and then try to change to an F1. And
Oh,
even
okay.
that is not completely true. So in your case, it's definitely not true.
Okay, so there won't be any issue. Thank you so much, ma'am.
You're welcome.
We have another caller, Rahul. Hi, Rahul. Welcome to the show. Please go ahead and ask your question.
Hi, thank you. Ma'am, I had a question. I'm currently in Canada, and I'm on a PR year since past 1 year. And I have a EB2 priority date of 2013. So wanted to ask, how are the dates going to forward? What do you think the projection is going to be, like this year or next year? Will the dates come forward, like date of filing for green cards, or how is the trend going to be?
It's hard for anyone to predict. I wish we had a magic ball
Yeah.
and we could predict. And Ranjit has been asking me this question about the visa bulletin, and I haven't answered that as yet. So I might as well. I mean, but I'm sure you are following the dates very carefully, and you've seen that in the last few months, the final action dates have moved quite significantly. Every month it's moving. So for the April visa bulletin, EB2 has moved by 4 months, and EB3 has moved by 2 months for India, Indian national. So that's quite a significant movement. Otherwise, usually if you look at it, there's hardly any movement. For months together, there won't be any movement, or there'll be a movement of 1 week at the most. So they have said that there will be a significant movement in the final action dates, and we are seeing that. And as I said, it's possible that they might use the dates for filing again in October, because usually they do. But what we need to look at, usually October to March, they use the dates for filing. But what we need to look at is what the dates for filing are going to look like. Right now, the dates for filing are exactly the same as it was in October. So they're pretty good. But we don't know if it'll retrogress the dates for filing as well. But if it doesn't, then we're going to have another October 2020 and October 2021. So there'll be, some chance of filing, and if it moves forward, then, you might have a chance of filing, who knows. And you also have to remember the Biden administration has this immigration bill that hasn't decided whether it wants to pass it piecemeal or they want to do everything together. But one of the elements of it is the visa numbers, which is an important element of that bill. So let's see what happens.
We have another caller. Hi, welcome to the show. Please go ahead and ask your question.
Hi, ma'am. This is Ajay. I have a question, ma'am. Recently, last year, I went to India and did the stamping, H1 stamping on the same client. But this year, I want to go to India again in June. But my project, maybe it is going to end in April, in mid of April. So if I go to India in June, if I don't have project with me, is that okay, or like there will be an issue?
So if you're not going for a visa, and if you're on the payroll of the company and you continue to be on their payroll with or without project, it should not be an issue nowadays, especially. But again, whenever you leave the country and re-enter, remember it's at the discretion of the CBP officer to let you in or not let you in, and there's no appeal process for that. So, but in general, they don't ask you what is your project, what is, they'll see if your date is valid, they'll see who your employer is, and, that's about it. They might ask, so the only question they usually ask is, if your employer is in Texas, why are you traveling to Florida? And usually that's because your client is in Florida. So that's something like that might come up. But as long as you're on the payroll, even if you are out of a project for a short period of time, as per new guidelines that USCIS has given us, it doesn't follow that you're out of status. So the USCIS can use their discretion to continue to approve cases, even if they find that there was a short period whereby the person was out of project, as long as he was on the payroll.
Hi, Ajay. I hope that answered your question. Yeah, Prashanthi garu, if you have any updates, we are almost towards the end. So if you want to share the rest of the updates, that would be great.
Okay, so then the other update that I wanted to share was flexible. This is a rather long update, so I'll do part of it now and then maybe part of it next week. But USCIS also extends flexibility to certain applicants filing 765 for OPT due to processing delays. So what is happening is, because of the long processing time, just as H4 EAD we've been discussing, this issue is also, it's the same with the F1 EADs for OPT. And we all know that OPT is only for a period of 1 year. So what was happening is, by the time they process it, the OPT period will be over. So now they are basically saying that they're willing to give these people an OPT for a full 12 months from the date of approval, rather than looking at it from the time that the university college got over to 60 days grace and then 12 months. They're looking at it from the date that it was approved, so that the processing delay does not affect the OPT period in any way. This is great. This is absolutely
Yeah, we have one more caller. Let's take the last call. Hi,
Sure.
Ranjit. Welcome to the show. Please go ahead and ask your question.
Hi. So, as you explained, there is a proclamation 10052 which doesn't allow stamping for non-immigrant visa. So, how would the Dropbox facility really work? I'm kind of confused on that part.
So the
If I need
Dropbox
a
is for
stamping, I go to
extensions, and
internet.
the Dropbox is for extensions, and the proclamation doesn't apply to extensions.
What about the amendments?
It doesn't apply to amendments either. It only applies to those people who were out of the country, right, at the time that the proclamation took place. And there's also exceptions for H4s who are out of the country. For example, if their spouse is on H1, then it doesn't apply to them also. So you need to go and look at those exceptions. If you were in the country, in the United States, when the proclamation came out, it won't apply to you. So you can go get your visa stamped and come in. Now the only issue is, of course, how well the consulates are functioning, but if it's a Dropbox, then it should be fine.
Okay, thank you.
Okay, I hope that answered the question. We are towards the end of the show. Thanks, Prashanthi garu. Thanks for your time. If you would like to reach the attorney for a private consultation, please reach at 212-354-1010 or prashanthi@readyesq.com. Thanks for all the calls and watching the show. It was a great session with interesting topics and questions. Please call in every Wednesday at 5:30 p.m. EST to watch the Immigration Talk Show. Again, it's every Wednesday, 5:30 p.m. EST on Sakshi TV. This is Ranjit signing off. Thanks, Prashanthi.
Thank you. Bye.